Okay, so good evening, everyone, and thank you so much for attending this exciting event to mark the 80th anniversary of the commencement of the Nuremberg Trials. My name is Anthony Winton, a research fellow here at BIICL. I must begin by thanking my BIICL colleague, Kristen Hausler, as well as Dan Plesch at SOAS, Christoph Safferling and Kieran Manon at the Nuremberg Principles Academy, and of course to Elizabeth Hosier and her colleagues at the Robert H. Jackson Center, all of whom have worked together to make this event possible. We're also tremendously grateful to have the support of 9BR Chambers and SOAS for sponsoring tonight's event. So thank you so much indeed. These anniversaries have a special meaning for us at BIICL because several key figures at the Nuremberg Trials played an instrumental role in the life of our institute. And I think in particular of Sir Hartley Shawcross, the chief British prosecutor at the Nuremberg Trials, who was also a founding member of BIICL and was instrumental in the institute's management for many years over his long life. And hopefully Professor Eamon will be able to share some footage of Shawcross during the panel. But of course, today isn't only about commemorating a historic event and celebrating past achievements. Rather, what we hope to achieve today is to critically analyze the continued relevance of the principles established at Nuremberg for combating impunity today. And perhaps the most important legacy of the Nuremberg trials is the principle that any person who commits acts that are so serious, so egregious as to constitute crimes under international law, no matter how high that person's rank or station in life, they will bear individual criminal responsibility for those actions and can be held accountable. Moreover, that the principle that it's not acceptable to allow perpetrators of crimes of genocide, crimes against humanity, war crimes, or indeed crimes of aggression to hide behind abstractions and ascribe their conduct to the state in order to try to evade their criminal responsibility. And as the International Military Tribunal famously declared in its judgment, quote, "Crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced." Clearly, a foundational statement of modern international criminal law. Now, Nuremberg was not a perfect judicial process, and I think some colleagues might address some of those issues during the panel. But the principles it established created a framework for the future and played an essential part in setting international law and the world on a path towards greater accountability and greater adherence to an international rule of law. And we've certainly hit many tragic setbacks in our path from Nuremberg, not least in today's climate. But hopefully this event provides an opportunity to once again reaffirm our commitment to the Nuremberg Principles and to carrying the legacy of the Nuremberg trials forward. And we can look for no better example of someone who's dedicated their life to justice and the rule of law than our esteemed chair, Judge Joanna Corner. Judge Corner has more than 45 years of experience in criminal law. Prior to assuming her role as a judge, she's much too modest. Prior to assuming her role as a judge of the ICC in 2021, Judge Corner was a judge of the Crown Court of England and Wales, trying the most serious and complex criminal cases. Before that, she was a criminal barrister and a senior prosecutor at the ICTY, leading cases against political and military leaders for genocide, war crimes, and crimes against humanity. Judge Corner was also the senior legal advisor to the chief prosecutor of Bosnia and Herzegovina. And I must thank Judge Corner, especially as she is a steadfast supporter of our research into immunities and international criminal law here at BIICL, and gave our gracious lecture in 2023 on the theme of immunity and international criminal tribunals. So we're in the very best of hands, and I'll give the floor to Judge Corner. Thank you very much.
Can I borrow that? So, Anthony, you have to hold it. Thank you. Anthony, thank you very much, I think. The fact that I spent 45 years practicing in one form or another does not mean that I'm completely ancient. I just started young. Anyhow, welcome. Can I repeat Anthony's welcome to everybody? As you all know, the theme of this evening is 80 years on since the Nuremberg Trials. And in particular, I think the concentration is going to be on the question of immunities, which, as everybody knows, is at present of great public interest. Nuremberg said there was no immunity for heads of state, that the ICC says the same, that however, does not seem to be accepted by everybody. And I think, as I say, this is going to be the overarching theme. So can I fairly swiftly, and I'm afraid probably not at the same length because time is very short, can I introduce the speakers in the order in which they will speak? As I say, each of them will approach the overarching question from their own perspectives. Can I start with Professor Diane Ammon, who is the Regents Professor, Emily and Ernest Woodruff Chair in International Law of the Dean Rusk International Law Center at the University of Georgia, and additionally she's visiting academic at University College London, Faculty of Laws. But she's also served as a special advisor to the ICC, to the then prosecutor, Fatou Bensouda, on children as affected by armed conflict. And she's held a number of leadership posts in American and European societies of international law. Moving in from my right, the second speaker will be Professor Dan Plesch, who may be known to many of you, Professor of Diplomacy and Strategy at SOAS, a door tenant at number 9, which I didn't know, Bedford Row. He's an international relations scholar and historian, and in particular, his interest and his driving passion, and I've spoken with Dan on numerous occasions, is the UN War Crimes Commission, which is still largely overlooked in publications on the formation, the growth of international criminal law, and he's the author of a book on it. It's a real pleasure for me to welcome Professor Safferling from the Nuremberg Principles Academy. I see Christoph on a regular basis in Nuremberg for the moot court, which can I recommend to everybody? Best moot court anywhere, or moot competition. And Kirsty agrees with me. He holds the chair for criminal law, criminal procedure, and international law at the Friedrich Alexander University Erlangen-Nuremberg, and is, as I say, director of the International Nuremberg Principles Academy. And he's got too many publications, and they're all in German, so I'm going to miss well, all right, most of them. So I'm going to skip those, but I'm sure anybody who wants more information can go and Google everybody. Kirsty Sutherland to my left, barrister at 9 Bedford Row, specialising in international criminal law, did a long case quite recently at the ICC defending, and is co-chair presently of the IBA's War Crimes Committee. And finally, but obviously not least, Howard Morrison, the judge at the ICC, whose steps I'm endeavouring to follow, has had a remarkably varied career in one form or another. My favourite is when he was the presiding magistrate in Fiji. He wasn't content with just dealing with the law. He went out into the streets and stopped the coup. So he, as I say, has a remarkable wide variety of jobs. He was also appointed to KCMG in 2016, and before that practiced as defense counsel. I mean, was a judge in this country, but practiced as defense counsel both at ICTY and ICTR. So that was all the introductions I'm going to do. My brief is to not let anybody go over 10 minutes so that there is sufficient time for questions to come from you, the audience, and those who are online, to whom I also extend a welcome. So I'm going to endeavour to follow Elizabeth Wilmshurst, who I saw at Chatham House literally just stop people mid-sentence. I'm hoping not to do that, but there is a warning going to come. So can I start straight away, please, with Professor Allen?
Thank you so much. It's my task and my pleasure to present a historical overview of Nuremberg through the lens of our focus issue. And we start, of course, at the Palace of Justice, the courthouse where Nuremberg, the first trial took place. We note immediately we have 4 flags: the Soviet Union, France, Britain, and the United States, the allies who came together to establish and implement the proceedings at Nuremberg. I'm going to start, however, by focusing us on an event that took place 80 years ago this week, on December 4th, 1945. It was the day at court where the British opened their case. Each of the prosecution teams dealt with a different set of issues: conspiracy, crimes against humanity, war crimes, crimes against peace. And on December 4th, it fell to Britain to present its case. Doing so, at the lead was the man that you've just heard about, Hartley Shawcross, who was the very newly minted Attorney General of the United Kingdom following the surprise election of Labour after the end of the war. He comes to Nuremberg to present the opening, but that was not his first moment in the Nuremberg story. About 10 weeks before, here in Berlin, he read in English the indictment that had been handed down against about 24 leaders of the Nazi regime for the crimes that I have just mentioned. Now, even that was not the first moment in the Nuremberg story. Here in London at Church House, Westminster, 10 weeks before that, the 4 countries came together and concluded the London Agreement that established the International Military Tribunal Charter, setting up the structure that I've talked about, but for our purposes, most notably, including Article 7, which reads, "The official position of the defendants, whether as heads of state or responsible officials in government departments, shall not be considered as freeing them from responsibility or mitigating punishment." That abolition of immunity for governmental leaders was central, of course, to the Nuremberg Project, not least because one head of state, Karl Dönitz, who served after Hitler's suicide, was one of the defendants, and most of the other defendants were major leaders. So the trial couldn't have happened without this provision, which we'll be exploring throughout. Without further ado, however, let's see what Sir Hartley had to say about the Nuremberg Project.
And so we believe that this tribunal, acting as we know it will act, notwithstanding its appointment by the victorious powers, acting with complete and judicial objectivity, will provide a contemporary touchstone, an authoritative and impartial record to which future historians may turn for truth and future politicians for warning.
Now, this clip from Shawcross's speech is, in my mind, an echo of something that Jackson, the U.S. prosecutor, had said in his speech, speaking that we are establishing a record by which history will judge us, meaning the Allies, tomorrow, and in a rather more biblical sense said to pass these defendants a poison chalice is to put it to our own lips as well. And so we see both prosecutors talking about this as a warning, an admonition, a deterrent effort for would-be wrongdoers. And I like Shawcross's speech here because he gives us some touchstones, some metrics to think about the Nuremberg Project. Now, how did they go about establishing the record? These are some screen grabs from a Soviet film that show us, first of all, just how crowded it was in the courtroom. People were on top of each other, whether it was the defendants in the upper left corner, the judges in the upper right corner, the prosecution tables at lower right, or the many, many men and women who were translators, interpreters, etc., supporting the trial. They put forth buckets, rooms of evidence, often documentary, to try to establish the crimes, the record, occasionally interspersed with live witnesses, of which there were few, and some pretty gruesome camp films. It was tedious, boring, in fact, for most involved. We all have to admit as lawyers, a lot of trials are. This, because of the reading of documents, was even more so. And that's captured in a painting that hangs in the Imperial War Museum, done by Dame Laura Knight, already a very famous artist in Britain. She was the third woman ever to be admitted to the Royal Academy of Arts, and she was dispatched to Nuremberg to capture the proceedings. And if you can see it, she captures some of the boredom. Everybody's like this at the outset, but in the back, you see the orange there? She captures what I think is really important. The trial brought the war into the courtroom. It told of the devastation and the fire and the horrors of warfare in a way that could not be forgotten. And so she records the record, if you will, in real time. This painting was displayed even before the verdict was released. But I'd like to talk about another woman who was at the trial. You see her in the center here. She's only about 25 years old. She is a prosecutor at the E.J. Farben trial, but in fact had been working on war issues as a civilian attorney for the State Department and on the Nuremberg Project, both in Washington and in London. She was an expert in economic warfare and essential to all the trials of the industrialists. About 40 years later, 1980 or 1990, Belle Mayer, who later married Mr. Zek, writes, in hand as we used to do, a speech to talk to people about what she thought was the legacy of Nuremberg. And she says, "Many people have doubts about the wisdom of the Nuremberg trials, either because of some of the judgments or because of world events. However, in a hydrogen age," and here I think she means in the age of the hydrogen bomb, "we can no longer live by the law of the jungle. In terms of the development of a body of international law to govern the conduct of nations, the Nuremberg trials have established important precedents and principles. Despite the uneasiness of the times, No voice is raised today in defense of conquest, and no voice is heard to say that aggression is not a crime. Now that's a sentence that bears thinking about in our current moment. And of course, this is an important landmark of Nuremberg, to which I would add the finding that human beings could violate international law opened the door to understanding that human beings could be victims of international law. And so Nuremberg, in many ways, is the fountainhead of the international human rights movement. Now, having praised Nuremberg in this way, Zek then asks some questions. And you see them on her legal pad. At the bottom, she asks about the death penalty. Is justice done when 12 of the defendants, well, 11 are hanged for their crimes, the 12th having escaped hanging through a cyanide capsule? Is the death penalty something we move away from over time? Or do we need to think about the reinstatement of a death sentence for crimes against humanity just this past several weeks in an internationalized tribunal? She also asks about superior orders. When must people refuse illegal orders? Very important issue today, particularly in the United States. And what are the consequences if they do not? And then at the very top, she asks, what's the million-dollar question for this proceeding? Would Roosevelt have been tried? Should Churchill have been tried? Could any individual from the victorious powers, whether it be at Nuremberg or conflicts later, be tried under the principle of no immunity? Now, what was she thinking about when she imagined Roosevelt, for whom she'd worked as a civilian lawyer, might be tried? Perhaps, of course, she had in mind the dropping of 2 atomic bombs in order to end the war. There was at least one participant at Nuremberg, an FBI agent who was seconded, who went home, having been working on the evidence, and said, if we can do that, we cannot judge these people. And so those questions were there. We note as well, if we look at the circle at the bottom, this is the front page of the New York Times on August 9th. At the top is Nagasaki. At the bottom is the signing of the Nuremberg Charter. Those 2 events occurred in the same 24-hour cycle. So the birth of the nuclear age and the birth of the Nuremberg era occur simultaneously. But perhaps Bell-Mayer-Zek had something closer to mind. She may have been thinking about photos taken by a Life magazine photographer, Margaret Berkwhite, who later did an affidavit prepared by Mayer in the Krupp trial, where some of her photos from spring 1945 Germany were introduced. And the one that I don't think was introduced at the trial, but may have been in Bell-Mayer's mind, is this one. This is the Nuremberg that the participants encountered and lived with day after day. They were intimately familiar with the devastation that had been wrought, and visually and indeed from the smell, olfactorily aware of the fact that they were trying one side for bombings and devastation and remaining silent on their own. And so with those things to talk about, I'd like to conclude and thank you for your interest in this subject.
Thank you very much indeed. Perfect timing. Right, Dan, over to you.
Thank you very much, all of you, for coming, and a distinguished panel altogether. I should say that my work on this is in part a part of a project funded by the Leverhulme Trust on arenas of accountability, led by my colleague, Professor Clark, and with Professor Collins as well. But I'm certainly interested in more collaborations and volunteers to the project I will outline. Now, I was hoping that my magic, the screen would have appeared and the charge sheet would have appeared. Anthony, Sorry? Ah, wonderful. Thank you. On the screen, to which I shall wave at and hopefully not decapitate any of my fellow panelists, you'll see an international criminal charge sheet against Adolf Hitler and colleagues. The date is December 1944, and the arena is London, where Nazi V2, what we came later to call Scud, ballistic missiles were detonating at random. Hyde Park, St Pancras, you never knew until they went off. And in Belgium, the Nazis were preparing what we now call the Battle of the Bulge. On this charge sheet, against Hitler and his officials, if you look, you'll see the accusing country is Czechoslovakia. And the second line, Czechoslovak charges against German war criminals. And the whole form is the form of a bureaucracy. And as a researcher, the first one of these I saw put me on the hunt, because this wasn't, as it were, a scribbled piece of paper. What one might call a traffic ticket for war crimes. And they're using evidence provided by resistance fighters, smuggled to London from Czechoslovakia while still under Nazi occupation. The focus is on the operation of illegal courts in Czechoslovakia, brought in by the Nazis from 1940. And the serial number at the top, if you can see it, 424, and then the 10th of the Czechs against the Germans, indicates that this is a significant functioning bureaucracy at the time. And Hitler is charged on a standard charge sheet. There is not a separate form because he's head of state. In the box on the form, you'll see on the left, the number and descriptions of war crimes. And the first item, and this is taken from the charges approved at Versailles in 1919, but much forgotten today, is murder and massacres, systematic terrorism, a familiar practice of the Nazi regime, and underneath it, the different sections of the Czech Penal Code, which also apply. And in the addendums, these documents are all provided. This bilateral charge, I should say, by the way, that the reason that this body chose the Versailles list was because it had been accepted by Germany at the time and approved by Japan in 1919, and therefore the Commission decided it escaped the worst accusations of victors' justice, that these charges had international stature, including of the members of the accused states. This bilateral charge by the Czechs against Hitler was endorsed by the 16 member states of this commission, including the United States, which, as we all know, had had a dissenting opinion with respect to the Kaiser. Hitler was then listed as an accused war criminal, liable to arrest by any member state. But Hitler was not accused by the Commission itself, as this was outside its remit. There was no requirement that Hitler be handed over to an international body, because it did not exist. At this time, in the winter of 1944, the IMD was still a distant dream, as the major powers had yet to determine how to implement the 1943 Moscow Agreement on war criminals. The member states considered whether heads of state had immunity as part of their deliberations through 1944. The Commission role was to provide an advisory opinion as to whether serving heads of state immunity existed, and they determined after some time, and there are committee minutes reflecting this, that it did not. Peacetime immunity did not apply between belligerents. Those giving orders were logically as responsible as those implementing or assisting them. That indeed the whole point of dictatorships was it was the dictator who gave the orders. And the severity of crimes, all of these weighed with the states and their representatives. That winter, the Commission went on to consider 15 separate charges from 3 European member states, amounting to a bundle of 2,000 pages of evidence, which we have online. And they determined, you might think unsurprisingly, that they met the standards of a pre-trial process. Separately, there were also charges against Mussolini. We should note Mark Ellis's key work determining that the UNWCC achieved good standards of fairness in its advisory opinions, its assessment of the individuals presented to it, and that in the 2000 resulting domestic trials, including the subsequent proceedings at Nuremberg and now the sudden notice of the trial of U-boat officers, men for killing shipwreck survivors, which has recently come into the news, that these trials met even current international standards. So this was no kangaroo court exercising some victor's justice. And perhaps anticipating Diane's remarks, the Commission considered in detail the issue of bombardment of cities and determined that where the cities were of military value, this was not considered criminal. And indeed, the Allies never brought charges against the Nazis for the bombing of London, Coventry, Rotterdam, and the like. This formal diplomatic body explained in its well-known 1948 history that it had its way in which it discussed the evolution of the responsibility of heads of state. The details were sealed, but the general policy was public. Since 1942, the St. James's Declaration made clear that those giving the orders were liable without exception to prosecution. National leaders made repeated statements on these lines, giving early and prior warning that retributive justice for those ordering, implementing, and assisting in war crimes was a major war aim of the Allies. So, for example, US President Roosevelt responded to the ousting of Mussolini by stating publicly that just because he had left office, he should not expect to escape justice, rather the reverse of the frequent position taken today. For those that need it, let's consider briefly a little more the validity of the state practice embodied in the Commission. According to Cassese, the UNWCC is a source of authority in international law. Not surprising, the national representatives included a former president and several members of the Permanent International Court, René Cassin, André Gros, and Sir Cecil Hurst of this parish amongst them. FDR sent Congressman Ambassador Herbert Pell, advised from Harvard by Sheldon Gluck, mentor of Ben Ferencz. And member states included China, India, France, the UK, the US, and many now members of the European Union. Poland, which was a leader in these diplomatic and legal efforts, held a commemorative event 2 years ago, addressed by the ICC president, and made a submission recently to the International Law Commission of its indictment of Hitler. In 2024, then President Assad of Syria faced criminal charges for gassing people, including French citizens, before French courts. The Court of Appeal in 2024 subsequently accepted the World War II cases that the bilateral prosecution of Assad by France was valid and referred the case to the Supreme Court. And I was asked to provide the memorandum, which you can find online. This demonstrated the policy of the French government in the 40s, led by Charles de Gaulle, including the precise dates on which the Commission reached each of its decisions and the way in which France supported them. Why do I bother with such detail? Well, the French court's own rapporteur noted the existence of these cases in relation to the personal immunity of serving heads of state, but unfortunately, the Supreme Court determined, without any explanation or discussion of the evidence before them, that no such past practice existed at all, and that serving heads of state were entirely immune from bilateral prosecution by another state, even for the most serious crimes. However, it said, now that Bashir has left office, he is, the court said, liable to charges under functional immunity. This upside-down decision offers no hint of redress to his victims or real-time crime, an incentive to the leader to remain in office so as not to become a criminal after leaving it. How absurd is that? Nevertheless, the Court's invitation to bring fresh charges under functional immunity for past heads of state pushes the immunity defence back further. At a minimum today, the World War II cases support the ICC's work in holding heads of state to account. Some argue that this is an innovative law. Not so, as we can now fully document, the World War II precedents give precise and detailed support for the idea of prosecuting heads of state. Now, to come back to Nuremberg, as I draw my marks quickly to a close, the UNWCC provided a social, diplomatic and scholarly context to the shaping of the Charter. Herbert Pell presented a definition of crimes against humanity in March 1944, more than a year before the famous conversation between Lauterpacht and Jackson. This is not to downplay the jewel in the crown that is the IMT, but to put it in a context of other gems of legal action. And indeed, the social movement of the time. We recently have a film on Nuremberg. On YouTube, you will find a Oscar-nominated movie, None Shall Escape, from 1944, which pans across a panel of, no doubt, Hollywood extras, indicating that sitting in Poland is an international court including Africans, Chinese caricatures, and Indian caricature judges in this panel. But by the late 1940s, FDR and all his works were reviled, the New Deal was set aside, and very pro-German anti-Semitic officials had come to office.
That's it, Dan. Sorry about that.
That's all right, that'll do.
Otherwise, we really would not have time for questions. Thank you very much, Dan. And I wonder if Russell Crowe is interested in watching that. Yes, and I turn now to Mr. Nuremberg himself, Christoph Safling.
Thank you. So it's so lovely to be here. Thank you so much. Warm welcome to everyone here in the room, to our moderator, panelists, and everybody online. It's a pleasure to be here. I think I've been here last in 1998, listening myself to a speech by the great Chris Greenwood. I think it was on war crime charges at the Yugoslav tribunal at that time, obviously. So now I'm back here myself, very honored. So thank you for inviting me. In this special moment in time when we talk about 80 years of Nuremberg and the achievements and the legacy of Nuremberg. Thank you so much for my esteemed colleagues who's sort of laid out already a lot of this Nuremberg legacy, and let me maybe connect to what they have been saying. It's interesting, though, that much of the benefit and the applause of Nuremberg goes to the United States and the great Justice Jackson being the chief prosecutor of the United States, whatnot. But obviously, here in this country, a lot has also been done, and a lot goes, to Shawcross and others who've done this, who have prepared for this trial and have then conducted this trial also very, very brilliantly. So this morning I was visiting Church House to see where the London Agreement was actually drafted and the London Conference convened. We didn't find the room, though, I have to say. We have some photographs, but we couldn't sort of identify the exact room. So in case you have other photographs, please forward them to us so that we can continue our quest where exactly this very important document was drafted and then agreed on. So it's fantastic to be here. And while we were just listening to Shawcross, it was most impressive. Thank you so much, Diane, for showing this little excerpt of his opening remarks. And you saw or heard that he was speaking so nicely, outspokenly, and slowly. And that was because the Nuremberg trial at that time obviously was not only the birthplace of international criminal law, it was also the birth of simultaneous interpretation. For the first time in world history, simultaneous interpretation was practiced. And so, they were used to then speak slowly in order for, 4 languages that needed to be translated into 4 languages. And at that day, actually, the 1st December 1945, I don't know whether you know what took place in Nuremberg at that time. It was the 11th day in court. The trial was opened on 20th of November, 21st of November, Jackson's opening speech. And then the following days, they were interviewing one of the crown witnesses of the prosecution, one Erwin Lahus. He was a high-ranking officer in the German Wehrmacht, in the counterintelligence, the Abwehr, as it's said called in German. And he could give details about the structure of the Wehrmacht and even, had a lot to say about, in particular, those military leaders that were in the dock as defendants. And on the 1st of December 1945, cross-examination started. And that's quite an interesting time also in this trial, because for the first time, German Defense Council were sort of trying out cross-examination. You might or might not know that German criminal procedure does not rely on cross-examination at all. Quite to the contrary, questioning the defendant, questioning a witness is not really, on the task of a defense counsel for many reasons, and we can have seminars on that, so I won't go into details, but they had to conform to the IMT charter, so they did cross-examine. And at some point, Otto Kranzbühler, at the end of the day, he came up to the rostrum and asked Lord Lawrence, the president of the tribunal, whether or not, in order to clarify, interpreting issues, whether they could have transcripts of what the witness says. And Robert H. Jackson stands up and says, that's not an issue because we are recording everything. We foresaw that there would be the need to look at the witness statements in detail. So Lord Lawrence asked Justice Jackson, and are transcripts being sort of provided then also to the defense counsels? Obviously they weren't, and that also speaks a lot of Justice Jackson's relation to the defense, because he wasn't really, doing as much as possible to make defense counsel's life easier. You might know similar situations, Christine, I suppose. Anyway, that was sorted, and transcripts were being provided. But that was the 11th day. It was a Saturday, by the way. Do you work on Saturdays?
Of course.
Sometimes, of course. Well, in court. In court. But they then took the Sunday off and convened again on Monday at 10 o'clock. Nuremberg at that time, as we have seen, was a totally destroyed city. 90% of the inner city was destroyed. And the reason why the Palace of Justice was still standing at that time was actually the fact that it was about 2 miles outside of the inner sort of ancient medieval town, Nuremberg. I was just this summer, on the 1st of August 25, I was in a concert in St. Sebald Church. You saw a picture of the destroyed church just a moment ago. And the performance was The Creation by Haydn. You might know this wonderful oratory. And that was actually a concert remembering a 4th of August 1945 performance of that in the ruins of the church. You've seen the church. In the ruins of the church. Amazing, I thought of that in that moment, that people were so desperate also to culture and art that they were traveling miles from all sort of outskirts of Nuremberg to listen to this music, have some sort of hope in this totally destroyed city of Nuremberg. Whether US or UK personnel was present, I wasn't, I'm not aware. But there were 3 contemporary witnesses still present at that concert this year. 3 elderly women that were little kids at that time and, accompanying their parents because they didn't have a babysitter, so they needed to drag them along. Quite touchy stories that I heard. But this is the surrounding of this so impressive historic event, the Nuremberg Trials, and all that we've heard about the importance of international criminal law being developed here, at all these, high-flying and idealistic speeches that were given by Jackson, Shawcross, and others, down to earth. People in Nuremberg were actually struggling with everyday life. And so you could imagine that at that time, maybe Germans were not that interested in the trial in the first place. They had other things to worry about. But with this first trial, they were quite happy with it taking place. And I've spoken to several people, the age of my father, saying that they were happy when on the 1st of October they heard on the radio the judgments, death by hanging of all these all these, or most of these defendants. The attitude of Germans towards Nuremberg and its legacy changed in the subsequent proceedings and the denazification process that unfolded after that. From that moment on, Germans, every single German had to justify him or herself, say, what have you done during National Socialism? They had to fill out questionnaires. And there is where this sort of individualization in the Nuremberg trials, saying that those defendants are the ones who are culpable and guilty, that sort of switched, and you had to reflect on your own portion of responsibility. And all of a sudden, Germans were not that happy. And when the Federal Republic of Germany was founded, the policy was clear, anti-Nuremberg and anti-Nuremberg legacy. So that changed only in the 1990s, when after the Cold War, Germany was a unified country. And if the Western courts wanted to prosecute Mauerschützen, the border transpassers, and the GDR, the SED regime's human rights atrocities, they actually had to do quite a lot of thinking about the Nuremberg trials and the jurisprudence that came out of Nuremberg to adopt that now, and particularly with the principle of non-retroactivity, as you can imagine. So then, but in 1998, with the establishment of this Rome Statute for the ICC, Germany had changed its policies very much in favor of conducting international trials, of creating an international criminal court. In 2002, an international criminal crimes code was adopted in Germany, and ever since the ISIS returnees, which sort of began in 2015, the Federal Public Prosecutor has developed a scheme of sort of prosecuting international crimes, in particular those that took place in Syria, but in so many other situations all over the world. It has now 3 units exclusively focusing on international crimes, some 21 prosecutors working exclusively on international crimes, more than 50 policemen at the Federal Police working in the same field. And the problem of immunities has obviously arisen. And in a first case against an Afghan officer, torturing Taliban POWs, allegedly, or then he was convicted, and functional immunity at that time was ruled out. They said there is no functional immunity ever since Nuremberg. That is established rule of customary law. It is reaffirmed, the Federal High Court of Justice had reaffirmed that in later cases, and the German legislator has actually took up this and has now amended the German law and ruled out functional immunities. That does not say that there's no personal immunity for the Troika whilst they are in office, but there is no functional immunity before German courts for anybody else. 10 minutes, Joanna?
Fantastic.
Actually 11.
So German.
We're 11.
I was going to give you a bit more time.
Thank you.
Right. Thank you very much, Christoph. Right, Kirsty, over to you.
So unfair to come after Christoph with his sort of impish energy. I'm going to be giving a much more nerdy perspective on immunities, so forgive me for that. I think it's important, and also, if I could just comment on one thing you said about art. It's been really striking me a lot recently how art is the very thing that makes us human, doesn't it? And then just sort of this, I think we need it in this time. So yeah, I mean, I think we're in an era of great multipolarism and increasing fracturing. But I think the question of immunities is really one that brings into play both political and diplomatic and ethical questions. Functional immunities, as we've been hearing about, these are designed to protect head of states from prosecution in foreign courts, which is obviously, states consider this to be a very important feature of diplomatic and international relations. Obviously, it enables practical engagement, protects leaders from political harassment through the court systems. But what we're talking about is the distinction between the domestic arena and the international arena. So principle that there can be no immunity for international crimes is obviously baked into the foundations of the Rome Statute. And states have agreed to this, and a wide number of states spanning the whole region of the world, all the regions of the world. However, the ICJ has said no. To be able to recognise this as a customary international legal principle, you'd have to have both state practice, primarily, and opinio juris. And opinio juris relies on state practice and a legal finding that that state practice must be followed. Instead, in the international arena, and I'm being slightly provocative because I'm setting Howard up, this finding of opinio juris, or finding of alleged state practice, relies on judges relying on themselves and each other's jurisprudence in the international tribunals. Now, I don't necessarily think that's a bad thing. But the ICJ does, so that's a problem. Where I think there might be an argument, and going back to what Dan's been talking about and what Christoph has been describing, is that maybe we do have state practice if we go back and we carefully look at the inclinations of certain states. So let's see. My personal concern or kind of feeling about this is that international crimes themselves are erga omnes. And it's recognised by the ICJ that states have a duty to prevent and punish. In Bosnia and Serbia, and then in South Africa and Israel, the ICJ has confirmed that the duty to prevent has the status of erga omnes. So I'm wondering, what about the duty to punish? And I'm throwing that out there as a slight provocation to the ICJ. Heads of state commissioning, allowing, or even failing to prevent can never be lawful. So I'm just sort of wondering what the customary position therefore is on holding them accountable. I don't know. And then that raises, I think, the question, where is the line between immunity and impunity? And so what are these treaties for? What is the customary legal jurisprudence designed for? I don't know. But I think my other concern, and I'm basically throwing out a bunch of questions because I don't know the answers to any of these, and I'm not sure anyone in this room does either. It's not 1945 when there, I think, are legitimate concerns about victors' justice. It's also not 1998, which was a heady time of human rights enthusiasm and passion for Ben Ferentz's famous statement, law, not war. We're instead in an era of dramatic contradictions and contractions of internationalism and funding crises and domestic focus and an increasingly insular world. Also an era of devastating atrocities and political fragmentation. I've just come back from Uganda, where I was working with Ugandan judges on their international crimes division and their universal jurisdiction efforts, but also speaking directly to a lot of Sudanese people who I've been working with for a while now. And I'm going to be completely honest, my heart is broken. I was in floods of tears on Friday. I was very tired and jet-lagged, but it's not an easy time to be working in this field. And I think this is an era also in which the future of the international legal order that was so brilliantly catalysed by Nuremberg stands really at the precipice, and we need more than ever today to uphold the legal principles that are so hard won and so excruciatingly difficult to maintain. But to do that, law today has to be clear, doctrinally sound, enforceable and enforced. And I think we're in a very, very frightening time, and the work of my co-panelists is you know, increasingly essential. So with the ICC, its legitimacy and functional abilities are very much in question at the moment, just when we need this institutional strength and institutional confidence. So I'm wondering what the impacts of the arrest warrants issued for Putin and Netanyahu, heads of states of non-states parties, will be, and I'm watching closely. And in our current era of multipolarism, fragmentation, and dramatic shifts in global power, let's figure it out. let's discuss this after this. But I don't know how much time I've got left. How much time?
3 minutes.
Oh, fine. Okay. Coming in under time. I think it is important to end on a note of hope on this. I know I'm not really giving the perspective from the defence because I think we're all really of one endeavour in seeking to, as someone put it, if you work in the defence, it's because you really believe in the enterprise of international justice. I think that the work of the War Crimes Commission and of Nuremberg has directly fed into today's universal jurisdiction efforts, and I've seen in the last few years of my practice, and it's been a part of my academic work as well, is just the incredible drive and hunger for accountability. Whether we can fulfill those commitments is sorely in question, but I've been really seeing incredible work across East Africa, in South Africa, in Nigeria, and of course in Europe, especially in Germany. I think the Germans have been taking a really practical approach to achieving accountability in a sensible way, and there's a lot for us to learn from both you and from Uganda, I would suggest. And on that note, I will look forward to the questions and discussing all of these quite intractable issues later. Thank you.
Thank you, Kirsty. And I'll hand your extra 30 seconds over to Howard.
Do I get a point?
Yeah, boys. Well, thanks for everybody who's organised this and attended, and if it makes Judge Corner feel any better, 45 years is nothing. I was called to the bar 47 years ago, so there we are. If we allow functional or personal immunities in international courts or tribunals, they may as well not be there. So they can't operate under those circumstances. It's just practically impossible. And so it's contained in the Rome Statute. Nations sign the Rome Statute. Don't sign a treaty unless you are prepared to follow its strictures. And one of the strictures is no immunity. And that's vital and important. Article 27 of the Vienna Convention on Treaties makes it perfectly plain that states cannot avoid treaty obligations by invoking domestic law, even if that is shaped by customary international law to immunities. So once you've signed the treaty, you've signed the treaty. Now, South Africa signed the treaty, but of course they didn't arrest Bashir when he first went to South Africa, and there were various, I think, fairly nefarious moves to avoid having to do that, and he left. Although I think if he'd stayed very much longer, he might have been arrested. Nobody seriously expected Putin to be arrested when he went to Mongolia. Why? Because Mongolia is wedged firmly between China and Russia and depends upon both of those countries for everything. And what is actually more of a surprise is that Mongolia is a a member of the ASP, as is Afghanistan. So let's look at it from a purely practical point of view. If you're going to have immunities of any shape or nature, you're not going to have international trials for heads of state and senior military people. So you've got to choose between one and the other. And we've chosen not to have immunities, and that's the only way forward. Now, this really demonstrates how old I am. In 1963, I was a pupil at a military boarding school in Hamm in West Germany, as it then was.
I'm so sorry.
And we made a school visit to Bergen-Belsen. Now, this was only 18 years after Bergen-Belsen was liberated. It didn't have a fancy visitor centre in those days. It was about as raw as you could expect it to be. And I had read the diaries of Anne Frank, who was about the same age when she died as I was then, and she died, as you know, of tuberculosis as a prisoner in Bergen-Belsen. And the idea, if anybody had suggested to me that people who'd set up institutions like Bergen-Belsen or Treblinka or Auschwitz should somehow be able to escape liability because of some rule of customary international law, as a 14-year-old, I would have fallen about laughing or crying, which is more. And in fact, the next year, after that, I actually went to Nuremberg for the first time, and it was still half devastated. I had a close relative who was a Lancaster pilot during the Second World War and dropped bombs on German cities at night. And I asked him in his later years whether or not he'd ever regretted or worried about what he'd done. And he said yes, because they bombed at night. The bomb aiming was fairly primitive. You couldn't guarantee hitting the target. And I said, did you ever resolve it? And he said, yes. At the end of the Second World War, I saw the first black and white Pathé films about the liberation of the concentration camps. And I slept easy after that. They had to be stopped. So I take a fairly hard line on that, I must admit. Ukraine will not agree to any immunity for Russian leaders in respect of any of the 185,000 documented war crimes in Ukraine. They're not going to do it. Most of them will be tried domestically, and I'm heavily involved in training Ukrainian judges and prosecutors for that purpose. You get the law, you get the society which you deserve. How we manage to deserve the world that we have at the moment is rather difficult to explain from a rational or philosophical point of view, but we have to live with it. Unless we hold to our principles in terms of people being accountable, as was set out at Nuremberg, then we're not going to move forward very far. In fact, we'll move backwards, and that cannot be. And so I'm somewhat comforted by this, that the world seems to go in a sort of sine wave of multiculturalism and internationalism at the peak. Then it descends into nationalism and ultra-sovereignty and racism and false arguments at the bottom, and then it goes back up again. And it's probably a generational or a bi-generational sine wave of societal change. At the moment, we are pretty much at the bottom, and we can only hope that it's going to rise again. And certainly, the states will be leading the rise, I hope. I was talking to Charles Garraway before we set in, and he and I were agreed that if either of us tried to get into the States now, they'd take one look at our mobile phones, and that would be it. We'd be on the next plane home. I can't hide my views. So if we are going to move forward, then respect for international law, understanding that international law may appear to be harsh in some circumstances, but if that's not what the world wanted, we wouldn't have had 123 states sign up for the ICC in the first place. So there's been an enormous democratic move towards the end of immunity, and personal and functional, for international crimes, and that has got to persist and remain. Otherwise, as I say, we might just as well close the doors and go home. And it's the same for the future. If Ukraine sets up a special tribunal for aggression, then it's going to have to be without immunities as well. Otherwise, it's not going to work. Under the Ukrainian Criminal Code, Article 438, you can have trials in absentia, which they will have, and most of the trials going on in Ukraine in respect of war crimes are trials in absentia. Not the best, but I always argue better than no trial at all. At least the evidence gets into the public domain and names are named. So imperfect though it is, it can work, and we've got to support it and move forward. And I simply hope that British governments hold their nerve and continue to support the ICC. It needs it. As we know, at the moment, it's going through terrible strictures, sanctions against Karen Khan, the prosecutor, irrespective of the allegations against him, which have yet to be determined. Although if you read some of the press, they appear already to have been determined. But if he's given a fair hearing, that will be good. And the judges and prosecutors are also under sanction. Trump could close the ICC tomorrow if it sanctioned the court financially. It has the power to do that. I can't imagine a bigger disgrace. Thank you.
And exercise of impunity.
Thank you. Thank you very much, Howard, and you've come in well on time, which does give a chance for the audience to ask questions. I don't actually think we've had any online that I can see.
Presumably you'll be taking questions as well.
I will take questions. Whether I can answer them is another matter. I'm still serving judging at the ICC. But I think what we've heard tonight, everybody would agree, is how we've gone from the triumph that were the Nuremberg Trials, effectively, built on it the international, the ad hoc tribunals, the International Criminal Court, and I don't know, some people may feel, and I think maybe I did and others, that it's actually going backwards. So, before I ask any questions of any of the panelists, questions from the audience, this is your chance. Sure. Yes, Mr. Kerr. Wait a minute, you're going to get a mic.
Oh. It doesn't need one.
Does this work?
Yeah.
No,
No.
no, it's not.
It does. It does.
It turn it off.
It does. Just
Turn it on, maybe like that. Judge Corner said in opening that at Nuremberg there was no immunities for heads of state, and the ICC has said the same. And Judge Morrison said that we've chosen not to have immunities. My first opening question is, who are we in that context? Because when the ICC's jurisdiction is triggered by the Security Council exercising its powers under Chapter 7 of the UN Charter, it's clear that we are the international community as reflected by states who've consented to the operation of the UN Charter. But an important principle that was enshrined in the IMT judgment was that the IMT and the Nuremberg judgment simply represented the action of states doing together what they can do singly. And my real question is whether the court's recent jurisprudence on immunities, particularly the appeals chamber's decision in Bashir, which found that an international criminal court is of a fundamentally different nature to a national criminal court, or by a pretrial chamber more recently in Mongolia, which found that a multilateral commitment cannot be altered or superseded by any bilateral commitments that may conflict with the Rome Statute's objectives, such as, for example, the horizontal immunity obligations owed by a state party to a non-state party. Does that jurisprudence in fact represent an abandonment of a basic principle of international criminal law established by Nuremberg? as it represents states doing together what they cannot
Okay,
do.
George. Is there anything else you want to say? Okay, can you say two questions effectively? Firstly,
Who are we?
who are we?
And does the jurisprudence represent states doing together what they cannot do singly?
No. Right. Who wants to start from the panel? Crystal?
Well,
Howard?
I would say we are the collection of largely democratic states that signed up for the Rome Statute, and they had a choice. I went to the PrepComs in New York. The biggest by far delegation and the most active and vocal was that of the United States, and they did not sign up. Charles was there. If somebody had asked me at the time, having observed part of it, would the United States join, I would have said they certainly will, they're very involved. If they asked me the same question about the African states, I would have said some may, but very few. I would be wrong on both counts. And it's why the collective wisdom of the people there was to realise that if you had immunities, the whole purpose of the ICC and of international justice would be avoided. And you talk about, of course, Chapter 7 powers are very important. The ICTY and the ICTR had Chapter 7 powers. When I was a trial judge in the case of Karadzic, we invoked Article 7 on many occasions. In fact, we even got cooperation from Russia, who was no friend of the court. But that's what distinguishes really the ICC from the ICTY and ICTR. The ICC doesn't have Chapter 7 powers, and it relies entirely upon mature state cooperation, which it does not always get.
So don't the Russians and
This is no, Josh. You get the answers. You don't have to start debate.
Can I?
Yeah, there's somebody behind you. Would something like yeah.
So I think that the question you asked invites us to understand that there's a lot of complexity in the question of immunities. As to the ICC statute and states parties to the ICC, I think that the answer is clear. As to everybody else, I think we don't know the answer. There's a debate between the ICJ and the ICC. I think it's a debate that needs to be had. It asks questions about whether we're thinking from a classical international law perspective or something else. And I think to the extent that customary international law answers some of those questions, which are extremely relevant for universal jurisdiction being exercised by nation states, we also need to understand that the progress narrative doesn't work and that custom can move in both directions. And so I am surprised that there has been less attention paid to the US Supreme Court decision on presidential immunity, which is state practice from a court that has outsized importance in the development of customary international law. We see, for instance, Pakistan has immunized its Minister of Defense recently. There may be movement toward more immunities in the national systems, and if that's the case, that may change what the customary answer is. Normatively, many of us would not like that, but I think we have to accept that it's a really dynamic question outside of treaties where people have signed up as states parties to a certain policy choice on this.
Yes.
May I?
Oh, sorry.
Yeah.
Christoph, yeah.
Sorry, I have to live with three people answering here. You know, the German Federal Court of Justice, when answering this or addressing this functional immunity question, they really dig deep into the question of state practice. And I don't know, they have at least 10, 12 countries, you know, where they found evidence that they all adhere to this Nuremberg Principle number 3, that there is no immunity. For these crimes, we are only talking about the Nuremberg crimes, right? We're not talking about anything else. At least I'm not talking about anything else. Just the core crimes as they are now being found in the ICC. So there is, as it seems, a lot of evidence. I know that in the Senate that handed down the decision, there was a split. You know, they were not uniformly of the conviction that there is a customary rule. There was at least one judge who was heavily against it. But that's a different story. Yeah? The majority ruled. The majority ruled on that the principle, Nuremberg Principle number 3. There is no functional immunity before German courts. You know, that's as far as it goes. When we talk about who is we, I would actually go a step further. When we look at Justice Jackson's opening remarks in Nuremberg, he says something like, a paraphrase, this is a court established by these 4 allied powers, and these 4 allied powers are acting as prosecutors, but that's merely accidental. The prosecutor is actually humanity. I think that's a very powerful statement, and we must keep this in mind, you know. And this also applies to the ICC. The ICC, of course, formally is a court of the 125 or whatnot member states, but it's a court representing the thrive and hunger for accountability that you were mentioning of humanity as such. So we is also humanity.
Anybody, Kirsty, do you want to add anything? Yes, we have the...
Am I okay to go?
Yeah.
Is that okay? Thank you. My question is much less intellectual and legalistic because I am not a lawyer and I can't live in those waters. I'm from Wilton Park. We're nearly as old as the military tribunals. We were born in 1946 to talk about the restoration of and the building of a new Germany. I wanted to come to Kirsty's point about multipolarity. At Wilton Park, we deal with multipolarity every day and the rising influence of emerging powers and the dilution of perhaps Western primacy and normative power. And I just want to ask you what you think, who do we need on our side these days? Because America appears to have left the building and Russia is not going to uphold a kind of normative importance of international law. So who among the rising powers that we need to contend with and collaborate with and work with is still to play for? They may be signatories to the Rome Statute, but are they advocates for international law and justice? Who do we need on our side, and how do we persuade them to be more vocal in joining the we that we are talking about? Thanks.
Right. Well, in fact, there's a question from someone online that perhaps goes on with that before I pass over the panel. Is there any jurisdictional basis for the ICC to charge Trump with obstructing the administration of justice, given the sanctions he ordered against the ICC? So the question is, who do we want on our side? Howard?
The easy question.
In practice, what we need, most of the members of the ASP are functioning democratic states. Some function better than others. Right? So what we need on our side is Democrats who actually believe in the rule of law, who do not believe in authoritarian government to the detriment of the rule of law. And who will stand up and be counted when the decisions have to be made. And I'll just take one example. I do a lot of the training of Ukrainian judges in Poland. It's safer. You don't put 50 judges in Ukraine into one building. You're inviting a drone through the window. So we take them to Warsaw or Gdańsk or Krakow and train them there. Poland has impressed me enormously in many ways, and hope I'll be forgiven for that. Economically, it's the new Germany. But militarily and in terms of standing up for what it regards as the rights of a democratic state to control its own destiny, I think Poland is a pretty shining example. There are, people in Poland who you would say were not indicative of that, but most of them are. And what we need is more Poland.
I totally agree.
I recently got quite stroppy with an MP. I know, it's hard to believe. Because he was sort of suddenly bleating on about the UK as the sort of leader of rule of law and how we needed to stand up and all the rest of it. And the thing that struck me was that I think the UK needs to be acting with a great deal of humility right now and actually put its money where its mouth is, kind of thing. But I wonder if the question is actually, whose side should we be on? Because I've seen enormous efforts and really committed independent judiciaries in developing states or countries that we would perhaps formerly have described as global south or developing, when really they are taking moral and financial and practical leadership when we're not, and so perhaps we need to be supporting them more than we are, and so not saying who are we going to get on our side. And I think we have some quite difficult, and I understand the complexities of the politics behind it, and I understand that we put our economic interests ahead of human rights interests often. We've got some very uncomfortable bedfellows and relationships that Europeans prioritise to the detriment of other nations, and I think we need to look at that a little bit more closely and start taking some moral leadership, and then we can ask who wants to be on our side with a little bit more credibility. Well, sorry, that was really doom and gloom. But
I think there's a good question here, I think, from somebody called Charlie Littlewood online, saying, thank you very much, fascinating discussion. What do the panel members think about the idea of charges being dropped against alleged international criminals as part of an effort to secure an otherwise just peace, or in order to ensure peace, which is something that comes up an awful lot? So, would somebody like to... Christoph?
I can maybe start with an anecdote here. In my class on international criminal law, I always do a mock peace negotiation at the very end. And so this is the UN General Secretary inviting two states, that have been at war with one another. Horrible crimes have happened. So it's the UN Secretary General, it's State A, State B, it's an NGO who's sort of, voicing victims, and it's the ICC prosecutor who has an arrest warrant against the president of one of the states. So when I started to do this in, I think, 2008, when I was still at the University of Marburg, I was sitting in the room and this play unfolded, and after about 45 minutes, I really almost left the room because I wanted to shout at this ICC prosecutor to leave the room and let peace be possible. Because he insisted that he's not going to take back the arrest warrant, and the states couldn't agree on anything because of that. So when I do this now, the discussion is never as principled as it was then. It's always about how do we do this with the criminal accountability. We will set up a special tribunal. We don't like the ICC. We'll set up a special tribunal. We will do this domestically, whatever. But the general idea of having accountability is actually not questioned. So this is a student play. So, but there is something maybe to be taken from that. First of all, obviously, they have listened to my lecture. No, just kidding. But I think that really terms have shifted. In 2025, we are talking law when we talk about war, and we are talking about accountability from the very first bullet, as has been the case in Ukraine, as has been the case in Gaza and other places of the world. So international criminal law is there. You have to deal with it in one way or the other.
So having had the privilege of serving as special advisor to Fatou Bensouda, I feel like I need to channel her here. She was asked this question so many times in conferences, and her answer would be that as the ICC prosecutor, she is bound by the statute to go forward with investigations and take them where they lead them. The question of so-called peace for justice is a question for the political bodies of the international system, and the statute provides for deferral by the Security Council for 1 year, presumably renewable ad nauseum, and that would be the way that that would be done. And the fact that that's not a possible thing because of the dysfunction of the Security Council may be an issue that is looming over much of the discussion about the functioning or dysfunctioning of international criminal law writ large.
Yes.
Hi, sorry, I have the microphone. My name is Oscar Rombulo. Thanks to the panelists and thanks to the audience. Sir Howard Morrison, quick question. You mentioned that we're at the end of the cycle. Why do you think that's the case? Why are we not at the beginning of the cycle? So that's my question. Thank you.
So the lowest point, hopefully.
Okay, I'm afraid we're running very quickly out of time. We've got, I'd say, time for 2 more questions. Yes. Right. Okay. Do you want to give? Do you want to give an answer then?
Yeah, very quickly. This is more what I hope than what I see. But I mean, you've got to have hope. The antidote to hopelessness is not hope; it's planning.
Right. Yes. I think gentleman in front. Yeah. I just hand up sometime.
Marco Longobardo, University of Westminster, Peace versus Justice. We have also the interest of justice that we could test. Even if the prosecutor said it is not the interest of peace, this hasn't been tested yet, judicially. My question is, after the al-Bashir decision that many don't like, for the reasoning, not for the outcome, we had a certain state practice, opinion juris by states in relation to the arrest warrant against Putin. I think that's state practice, opinion juris, that is significant.
Yes,
France,
ask the question, please. Sorry.
Arrive at the point, madam. France argued that we will arrest him because the ICC said that we have to do that. Then arrest warrant had been issued against Bibi Netanyahu. France said, no, we made it wrong with Putin. You misinterpreted us. We don't arrest anybody. What do we do with this state practice that fluctuates for political reasons? Thanks.
Right.
Ignore it.
Anybody else?
And a quick question for you, if I may. Who thinks that the power of veto, a single veto in the UN Security Council, is past its sell-by date?
100%. I wanted to do it here.
I couldn't possibly answer that one. Right, thank you very much. Yes, gentleman to that.
Get both.
Yeah, I'll get the
Thank you. Dan, you briefly mentioned the Moscow Agreement of 1943. I know that it existed, but it's hardly ever mentioned. It's almost as if it's been written out of history books. The stipulation made was that superior orders would not be accepted in any future trial, and also that all trials, apart from the leadership, would be held locally. But perhaps you could shed a bit more light about that. And could you also perhaps compare the Nuremberg trials with the Tokyo trials and see if you come to any conclusions?
What, in 30 seconds?
Yeah.
There's a book or two. The commission that was established provides a great deal of state practice, which is available if you want to study it, on the issue of immunities and a host of other issues. But even before the Moscow Agreement, the St. James's Declaration of January 42 makes it very clear that, without exception, ordering, committing, or assisting are all crimes. None shall escape. And the leaders of the time, Sikorsky, de Gaulle, speaking at that meeting, all explicitly confirmed that. So what went on, and which you see in that document I showed you, is subsequent to that. But I just want to speak to the questions that came just now. And so if you cast your mind back very briefly to the period that we're talking about, the St. James's Declaration was issued when the Nazis were sitting outside Moscow and the Japanese had just started to run across Asia. At that point, the fact that 9 countries could come together and envisage a post-war legal system to hold people to account was a fantastic pipe dream, far more unrealistic than anything we contemplate today. And when it comes to the issue of peace and justice, it is very inconvenient to remind ourselves that until very late in the war, there were deep concerns everywhere that either the Russians or the Americans would cut a deal with the Nazis. And that was one of the reasons why the European states were so keen to get the charges on the books against Hitler and the rest of his entourage, because they saw what might be coming. And there were powerful forces, at least in Washington, who were very much inclined to that. And they did everything they could to block Roosevelt's policy, as I've detailed.
Thank you very much. And one last question, gentleman in the back.
Thank you very much. Steve Crawshaw, there have been endless articles in the past year and a bit beyond that has said that the International Criminal Court has been too bold, in effect, by issuing arrest warrants first for the President of a permanent member of the Security Council, then for Prime Minister of America's best friend. I was interested, when I was writing a book on these themes, was in Israel talking to the distinguished human rights lawyer, who many in this room will know, Michael Svart. It's coming, I promise. It'll be about 20 more words. That his argument was, if you don't go where the evidence leads you, then you are destroying the institution itself. That was before the Netanyahu arrest warrant was issued. So I'm interested, it could be to any, I'm particularly interested, for example, Professor Saffelin, but could be any. Is it more important to have the sense of the ideal and the principle, or is it more important to go with the practicalities and the dangers that go with that? Any of the panel on that? Thanks.
That's a very good question. Yes. Yeah. Christoph.
Well, thank you so much. I mean, it's difficult for me to comment on the prosecutorial policy of the Office of the Prosecutor of the ICC. It would certainly not have been my strategy. I would have gone a different avenue, maybe more like the ICTY that started with middle, low-rank personnel, established jurisprudence, everybody used to the idea that crimes are being prosecuted, and then go for the top leaders. But Karim Khan obviously had a different strategy, and it's an extreme important symbol, an arrest warrant to say that, stop, you're committing crimes. Obviously, they don't stop. They're continuing to commit crimes, but I think it is of value, in particular for the victims, that they see that, somebody takes up something and at least issues arrest warrants. But from a prosecutorial point of view, I have my doubts whether this was wise to go this way, or, don't go for the middle ranks, lower ranks, to see that actually trials are happening. We certainly could find defendants of that rank that you could start both in the Palestine situation as well as in Ukraine.
I think that
I don't think we should allow political wins to override law. I mean, that's if the evidence says that this crime has been committed and this person was ultimately responsible, then I think we have to go for that. And I'm not getting into the politics of what the ICC sort of prosecutorial discretion exercise was, because I have no idea. But I think if we're talking in the abstract, then we can't have it that we let resourcing issues, or these are practical problems that the ICC faces, that the UK courts face. I mean, we've got there were 17,000 referrals to the modern slavery monitoring mechanism in a one-year period, 2023-2024, and 58 convictions. We've got a serious problem. So I mean, it's an endemic issue, but I don't think we can allow the law to be at the whim of political wins.
No. And from a practical point of view, the ICC has very limited capacity. Yeah. It's a big building, but it's a small court. 3 courtrooms, compare that to the 20-odd courtrooms you get in a provincial London Crown Court Centre. 18 judges, of whom 5 of us were permanently on appeal, only leaves 13 judges to do all the pre-trial and trial work, and it has the same annual budget as the Berlin Fire Brigade.
Right.
Do I need to say more?
All right, there is one sentence, one question that is capable of a sentence answer, I think, probably. This is from somebody called Vadim Atnash, who says his uncle was a member of the Tatar resistance, was guillotined at Plötzensee in Berlin in 1944. Was this method of execution discussed at the Nuremberg trials? Why was hanging chosen instead of a firing squad? Does anybody know the answer?
The guillotine was the ordinary way, according to German law,
Yeah.
to execute people.
So, but it just, you don't know why hanging...
I think that you need the mic.
Diane,
because
I
it's online.
don't know why hanging was chosen, although it may have been a cultural preference of the Americans, but it may be of interest to know that the condemned defendants, themselves requested the choice of firing squad on the premise that that was a more honorable execution for military officers. That request was denied.
Right.
I think that your answer.
And Christopher, you're saying, of course, guillotine was yeah, because they didn't need.
Yeah, no, I misunderstood the question. I mean, Diane is totally right. I mean, there was a disgraceful way of executing, to be hanged. And
Disgraceful?
That was, yeah. What do you mean?
As in they wanted them to be
I think it's
disgraced.
ridiculous to think that hanging is disgraceful, given what the perpetrators have done themselves.
I agree with you on that, and it's in particular, from a German perspective, without ruled sort of death penalty in 49. So why do you differentiate between different modes of the death penalty? I can't see any difference, but it made a difference then. And Goering committed suicide before the death penalty was executed. He might have stood up to a firing squad because he thought that would be the death penalty he deserved, and to be hanged. Yeah, I know it's ridiculous, but I think that was what they were thinking at that time.
But the guillotine was the normal.
The guillotine was the normal way of, a capital sentence according to the German criminal code until 49 was
Under Weimar?
Also, yeah, ever since 1871.
Right, well, I thought that was going to be a nice, simple topic on which to end this. All I can say is that it's turned out to be a very, very interesting question. It was always interesting, but I think we'll have to end it there because we've run over time. Can I thank, as I'm sure everybody else wants to, the panelists who have given such interesting, varied information. So thank you all very much. And one last thing, a number of you have asked online for information, which I haven't read out because it's more that I don't know whether it can be answered, Anthony. There are a couple who want some help on things.
Yes, absolutely.
Yeah.
They can email me.
Yeah. Okay, so anybody who's online whose question hasn't been answered, and in particular, I'm thinking of the students who want to know about the doctor's trial, if you email Anthony Winton, then he may be able to assist you. So thank you all very much.
Wonderful, thank you. And just say we will now have a small drinks reception downstairs, so I hope you'll all join us as well. Thank you.